Next matter the court is going to take up, State of North Dakota versus Alex Maxwell Schenk, 02-2026, CR 42. Again, present in the Barnes County courtroom, Attorney Trent Jackson. Alex Schenk appears personally without counsel from the Barnes County Correctional Center. Mr. Schenk, can you hear and see me okay?
Yes, Your Honor.
Were you present in court when your rights were read to you?
Yes, Your Honor.
Do you understand your rights?
Yes, Your Honor.
Were you present when I had court with your mother?
Yes, Your Honor.
And at the beginning of court with your mother, I explained that Ms. Chisholm is typically appointed to represent people in custody at this initial appearance, but she is unavailable for court this morning. I have found probable cause in writing over the weekend. I found probable cause late last night, and I did set your bail pursuant to the scheduling or the district's 9th revised bail schedule. We can move forward with today's initial appearance without counsel if you would prefer, or we can reschedule today's hearing for a later date, considering I have already found probable.
The judge carefully explained every right Alex was giving up by pleading guilty, but Alex still chose to move forward without a lawyer and accept responsibility for his actions.
Probable cause and set bail. Which would you prefer?
I just want to move forward with the meeting today.
Has anyone threatened you, forced you, or coerced you, or made any promises with you, to you in order to get you to waive your right to counsel?
No, Your Honor.
And you understand that you can change your mind and apply for counsel at any time or hire a lawyer at any time if you wish?
Yes, Your Honor.
Court will find a knowing and voluntary waiver of the right to counsel for today's purposes. Mr. Schenk, what's your plan long-term for counsel?
I don't need no counsel. I just want to get this taken care of and hopefully go home today.
All right. So court will find a knowing and voluntary waiver of the right to counsel. Mr. Schenk, have you received a copy of the charging document in this case?
Yes.
Is your name spelled correctly on that charging document?
Yes, Your Honor.
You have the right to have that document read to you in its entirety, or I can summarize it for you.
Summarizing is fine.
The state alleges that you committed one crime on or about February 21, 2026 in Barnes County by committing the offense of hindering law enforcement by providing false information or a false report to law enforcement which interfered with, hindered, delayed, or prevented the discovery, apprehension, or prosecution, conviction, or punishment of another person. This charged, that is a Class A misdemeanor. Class A misdemeanors include a maximum penalty of 360 days in jail, a fine of up to $3,000 or both. The state has not alleged any minimum mandatory penalties other than a requirement that you submit fingerprints for inclusion in law enforcement's databases. Court fees associated with a Class A misdemeanor total $325. If your conduct caused any loss or financial harm to another person, the court can order restitution. If you are not a United States citizen, a conviction can result in significant adverse immigration consequences. It might also result in other adverse collateral consequences for which the court is not required to explain. Do you understand the nature of the charge and penalties as I've read them, sir?
Yes, Your Honor.
Because you were charged with a misdemeanor, I am going to take a plea today of either guilty or not guilty. If you plead not guilty, we will schedule further proceedings in your case and set your bail. If you plead guilty, there won't be any trial of any kind. You'll be waiving the rights that were read to you before, and you would likely be, or your case would likely be resolved today. Do you understand what happens if you plead guilty?
Yes, Your Honor.
Do you understand what happens if you plead not guilty?
Yes, Your Honor.
To the count of hindering law enforcement, Class A misdemeanor, to that count, how do you plead?
I plead guilty, Your Honor.
Before you do that, do you understand that you have the right to plead guilty or not guilty?
Yes, Your Honor.
And that by pleading guilty, you're waiving the right to a trial of any kind to a judge or a jury in a jury trial for either 6 or 12 persons if you demand to unanimously find you guilty before you could be found guilty and punished. You're waiving the presumption of innocence, the requirement the state prove you guilty beyond a reasonable doubt, the right to confront and cross-examine witnesses against you, the right to testify or remain silent, the right to present witnesses and evidence against you or on your behalf, to use the court subpoena power to force those witnesses to appear. You're waiving all defenses that you could have had. You're waiving all non-jurisdictional defects in the case if there are any, and you're limiting your ability to appeal the case if you enter unconditional guilty pleas. Do you understand all the rights that you're waiving by pleading guilty?
Yes, Your Honor.
Do you still want to plead guilty?
Yes.
Has anyone threatened you, forced you, or coerced you or made any promises to you in order to get you to plead guilty?
No, Your Honor.
Has anyone told you that you have to plead guilty?
No, Your Honor.
Are you pleading guilty freely, knowingly, and voluntarily?
Yes, Your Honor.
Do you need any additional time to speak with a lawyer about your rights, defenses, the plea that you're offering, or the potential for the court to sentence you?
No, Your Honor. I just wanted to say something to the judge in the court if I can, whenever.
I'm going to give you an opportunity to do that.
Yep.
Are you pleading guilty because there's a plea agreement in place?
No.
No. So just stick with me for a second here. Mr. Jackson, what would the state's sentencing recommendation be if Mr. Shank were to plead guilty today?
Your Honor, the state's sentencing recommendation would be for the defendant, it would be 360 days, first serve 30, credit 2 days, unsupervised probation for 1 year, standard fees applied. And the 2 days would be for time actually served. He wouldn't have any credit for good time.
Mr. Jackson, is there prior offenses that I should be aware of?
Your Honor, 1 second, I want to double check. I looked earlier today. I believe the defendant is already on probation currently, supervised probation. Your Honor, it appears that the defendant was placed on supervised probation in Barnes County case from 2025, ending in 131. In this case, Your Honor, he was placed on supervised probation starting 5/6/2025, and that was for 18 months. Your Honor, this is a new offense. The defendant supervised probation didn't seem to keep
Mr. Jackson, stop. All I'm asking is, does he have prior Class A misdemeanor or Class C felony convictions? Because otherwise, this is a presumptive probation case.
I apologize, Your Honor. Yes.
For what?
This would the case that I previously referenced, Your Honor, 2025 case ending in 131. It was a Class A misdemeanor, domestic violence, bodily injury, second or subsequent offense.
Mr. Shank, does the state sentencing recommendation change what your plans are today?
I just know that I've done everything. I've done my domestic violence course. I've been meeting with my probation officer every Tuesday, and like my mom said, there is nobody at our house to take care of the house. I will still plead guilty and everything today. If I do get jail time, could I please do it on the weekends? And I got a job that I'm supposed to be getting this week.
Mr. Shank, all I'm asking, and I'm not going to get in the middle of what the state is recommending, or I'm not going to get in the middle of plea negotiations. All I'm asking is, you now know what Mr. Jackson intends to recommend, which is serve 30 days in jail and be put on probation. Does that change whether you want to plead guilty or not guilty?
That doesn't change if I want to plead guilty or not guilty, because that's not necessarily your sentencing, correct?
I'm free to impose whatever sentence I think is appropriate and just between the minimum mandatory and the maximum penalty. The state will make its recommendation. You will be given an opportunity to make a recommendation, but I'm free to impose whatever sentence I think is appropriate.
Okay, no, I'll just plead guilty, Your Honor.
All right. So, Mr. Jackson, a brief factual basis.
Yes, Your Honor. On February 21st, 2026, members of the Barnes County Sheriff's Office went to serve a warrant on the defendant's mother, Brenda Shank. She had multiple confirmed warrants. Deputy Pazek knocked on the door, and Sergeant Nathan Morton had observed the defendant's mother, Brenda Shank, who had warrants in the living room when they were serving the warrant or attempting to serve the warrant. The defendant, Alex Shank, walked to the front door. He told members of the sheriff's office, not once, but after given a second chance to tell officers that Brenda Shank was in the residence, he again lied and told them that she wasn't there. She had in fact gone upstairs from the living room, and he knew she was there. In fact, he told his girlfriend to call Miss Shank downstairs once he was being detained and then arrested. So she knew that, or he knew that she was there at the time that he was lying to law enforcement.
All right. Mr. Shank, is that what happened?
Yes, it was. I made a dumb mistake. I should not have lied to law enforcement, and I am terribly sorry. At the time, I was just worried about my mom. It is my mom, Your Honor, and I know that doesn't justify lying to law enforcement whatsoever, but at the time, it just happened. It was my mom, and it will not happen again. I can guarantee that. Like I said, I do apologize, and I've been seeing Tristan every month, and I've been getting a job, and I've been working on doing all my classes. I've been doing everything I can to become an actual working part of society and not end up back in jail, just like you asked me to, Your Honor, the last time I seen you. I really have been.
I'm going to accept the guilty plea and find it freely, knowingly, involuntarily, and intelligently entered. The court finds an adequate factual basis to support the plea. Based on the factual basis offered by Mr. Jackson and the declaration of probable cause just filed from Sergeant Morton. With that, I've heard the state sentencing recommendation. Anything else, Mr. Jackson, in that regard?
No, Your Honor.
Mr. Shank, is there anything that you want to tell me in terms of a sentencing recommendation?
Just if I do get jail time, to give me weekends so I can at least get out and take care of the house, all the flooding and everything like that, and take care of my dogs. And I mean, other than that, that's about it. I mean, I will be here to do every weekend in jail that I am given. I will be here every single weekend. From the point on that I leave, I will be here every weekend on the day that you tell me to be here. I will be here.
Anything else you want to tell me before I impose sentence, sir?
No, Your Honor. Other than I'm sorry, and it will not happen again.
Sentence as follows. 7 days straight time in the custody of the Barnes County Sheriff to be served at the Barnes County Correctional Center. Credit 2 days. Actual 0 days credit for good time credit. No probation to follow. Fines and fees waived. Sentence forthwith. Court authorizes work release and treatment release to the extent Mr. Shank meets criteria from the Barnes County Correctional Center. Fingerprints required. That's the court sentence.
So how many
Any questions? I impose 7. You have credit for 2. So I didn't do 30 days and I didn't put you on probation for this offense, but I did impose 7 days. You've got credit for 2. You likely will be entitled to an additional good time credit of 1, which will mean that you will still need to serve 4, and you're going to do that now.
Do that now?
Yep.
Okay.
So with that, we are adjourned. Have a good day.
Thank you, Your Honor.
First matter on the court's docket, State of North Dakota versus Brenda Arlene Shank, 02-2025 CR 299. Present in the large courtroom of the Barnes County Courthouse, Attorney Trent Jackson. Ms. Shank appears by reliable electronic means from the Stutzman County Correctional Center. Ms. Shank, can you hear and see me? Ms. Shank, just press and hold that button so it turns green.
Okay, I do apologize. Yes, Your Honor, I can hear you.
All right. Did you, or were you present in court when your rights were just read to you?
Yes, I was, Your Honor.
Do you understand your rights?
Yes, I do.
One of the important rights you have is the right to be represented by counsel at every stage of the proceedings. You are in custody, and the law presumes that you are indigent when you are in custody for this initial appearance. Ordinarily, there would be a public defender that would be assigned at this point to handle this hearing on a limited basis, and you can apply for a public defender if you financially qualify and wish to have a public defender represent you during the duration of the case. Ms. Chisholm, however, does have a conflict with the 9 o'clock time frame, and so she sent an email to the court indicating that she might not be present, and I don't see her connected at this time. What is your plan for counsel for the rest of the case, Ms. Shank?
Court appointed, Your Honor?
You'll need to fill out an application form for court-appointed counsel, and I will review it, and depending on whether you financially qualify or not, the court will appoint counsel to you. The purpose of today's hearing, Ms. Shank, is to make sure you understand what your rights are, what you're charged with, the maximum and minimum possible penalties, and to schedule further proceedings and set your bail. Today's hearing, because you're charged with a felony, won't involve a plea. Would you like the court to reschedule today's hearing to a time that Ms. Chisholm was available, or would you like to proceed today without counsel, knowing that you will apply for counsel shortly after today's hearing?
I will continue and apply for counsel, Your Honor.
So when you say continue, do you mean you want me to reschedule today's hearing for tomorrow, or would you prefer that we move forward today without counsel, knowing that you're going
Move
to apply?
forward today with, I'll move forward today without counsel.
Okay. Has
Your Honor.
anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to counsel?
No, Your Honor.
Ms. Shank, have you received a copy of the charging document?
Yes, Your Honor, I have.
Is your name spelled correctly on that charging document?
Yes, Your Honor.
All right. You have the right to have that charging document read to you in its entirety, or I can summarize it for you. Are you okay with the court summarizing it?
Yes, I am, Your Honor.
All right. So in the criminal information, you are charged with a total of 7 crimes. The state alleges that on or about November 5, 2025 in Barnes County, that you committed the Class C felony offense of stalking by sending TS multiple text messages, having previously been convicted of domestic violence bodily injury in file 47-2020 CR 486, where TS was the victim. As charged, again, that is a Class C felony. Class C felonies include a maximum penalty of 5 years in prison, a fine of up to $10,000 or both. The state has not alleged any minimum mandatory penalty for count 1, except a requirement that you submit fingerprints and DNA for inclusion in law enforcement's databases. Court fees associated with a Class C felony total $525. There are some other penalties that apply to all of the counts, so I'll talk about those together. In counts 2, 3, 4, 5, and 6, you are charged with the same crime relating to different underlying convictions. The state alleges in counts 2, 3, 4, 5, and 6, so a total of 5 counts, that you committed the Class A misdemeanor level offense, disobedience of a judicial order, by willfully disobeying or resisting a lawful restraining order or preliminary final injunction, by having contact with TS in violation of the no contact orders put in place in files 02-2024 CR 338 in count 2, file 02-2025 CR 30 in count 3, 02-2025 CR 31 in count 4, 02-2025 CR 32 in count 5, and 02-2025 CR 33 in count 6. Again, all 5 of those disobedience of a judicial order counts allegedly occurred in Barnes County on or about November 5, 2025. They all carry with it the same maximum penalty of 360 days in jail, a fine of up to $3,000 or both. The state has not alleged minimum mandatory penalties other than a requirement that you submit to fingerprinting for inclusion in law enforcement's databases on those counts. Court fees associated with the Class A misdemeanor total $325. And again, there are additional penalties that apply to all of the counts. We'll talk about those in a minute. Lastly, in count 7, the state alleges that on or about November 5, 2025 in Barnes County, you committed the offense of violation of a disorderly conduct restraining order, Class A misdemeanor for having contact with TS in violation of the disorderly conduct restraining order issued in 02-2024 CV 295. Again, that is a Class A misdemeanor, same maximum penalty, 360 days in jail, a fine of up to $3,000 or both. No minimum mandatory penalties except a requirement for fingerprinting for inclusion in law enforcement's databases. Court fees totaling $325 are possible in that count. For all 7 counts, if your conduct caused any loss or financial harm to another person, the court can order restitution. If you are not a United States citizen, a conviction for any of those counts can result in significant adverse immigration consequences. They might also trigger significant collateral consequences for which the court is not required to explain. Ms. Shank, do you understand the nature of the charges against you and the penalties as I've read them?
Yes, I do, Your Honor.
Do you have any questions about the charging conduct or the charging document or about why you're here?
No, I do not.
All right. Again, because there is a felony involved here, I'm not going to take a plea of any kind today on any of the counts. We will schedule further proceedings in your case. You will have a preliminary hearing and arraignment scheduled for March 26, 2026 at 1 p.m. in the Barnes County Courthouse. That date again, March 26, 2026 at 1 p.m. Barnes County Courthouse, Valley City, North Dakota. Do you understand when you next need to be in court, ma'am?
Yes, I do, Your Honor.
All right. Lastly, I'm going to address bail. So I'll hear first from Mr. Jackson. He'll tell me what he thinks about bail. And then Ms. Shank will give you an opportunity to tell me what you think I should do on bail. Go ahead, Mr. Jackson.
Yes, Your Honor, thank you. The state would request standard terms and conditions of bail, including no contact with TS, as Your Honor indicated, and as indicated by the information. There have been previous instances with the defendant offending against TS. The state submits that the state's evidence is strong. Based on these text messages, state would request that bail be set at $2,500 cash, or in the alternative, $5,000 corporate surety.
All right. Thank you. Ms. Shank, you don't have to say anything. You certainly can. This is a recorded proceeding. And so I want to inform you that you have the right to remain silent. Anything you say can and will be used against you. If you choose to remain silent, that will not be used against you. If you do make a comment, ma'am, I would advise you to limit your comments to your likelihood to appear in court and your likelihood to remain law-abiding, or your dangerousness to any individual in the community. So that would be my advice to you. Is there anything that you want to tell me about bail before I set it?
As far as bail goes, Your Honor, I am on a fixed income, and I have had to replace my furnace, and I've had to replace my kitchen stove and many other items, and I have no money for bail. I have no one I can ask for bail, and so whatever bail you decide, I will be sitting no matter what until March 26th. But if you let me out on a PR bond, I will get a hold of my lawyer and I will follow everything, and I will be in court March 1st or March 26th at 1 p.m. Other than that, Your Honor, I beg of you to let me out on a PR bond. I have a older home, and I know for a fact right now that the basement is probably flooding, and I have a pump. It's a pump I have to use. I have to manually plug it in and unplug it in order to keep it from flooding. And that's all, Your Honor.
Ms. Shank, the state has asked me to impose order prohibiting contact. And you tell me you're going to follow everything I said, but the charges here, and you're presumed innocent of the charges, but the charges here are for repeatedly violating or allegedly violating the court's restraining orders prohibiting you from having contact with TS. How am I to trust that you will follow my orders when you are accused of violating my orders in 7 different ways? And in this case, there was an outstanding warrant for your arrest for at least 3 months. How am I to trust that A, you're going to show up in court, and B, you're going to follow my orders if I do what you're asking me to do?
Your Honor, I will not, and I have not contacted Tim at all. I have in fact found on the internet where he was linked to my account, and I have sent it to Firmgen, and he has not said anything back to me about it or anything, but I am not contacting him. I do not, and I will not contact him. Our restraining order, I have till June 26th or June of 2006, and as you said, and I have kept that since I got out of jail. I have not contacted him. I did not contact him the 30 days I was in jail. I have not contacted Tim Shank, and I do not intend on contacting Tim Shank. I have no phone. I have no computer. I have no internet. I do not participate in any of that anymore. I have not, Your Honor.
All right, here's what I'm going to do. In light of the nature of the offense, court is going to set bail as follows: $1,500 cash, or in the alternative, $5,000 corporate surety. Additional conditions: defendant remain law-abiding, not come within 300 feet of TLS year of birth 1961, or have any contact directly or indirectly with TS except through law enforcement or your attorney. Since you've been charged with the crime of stalking, any violation of this no contact order provision constitutes a separate Class A misdemeanor criminal offense punishable up to an additional 360 days in jail. Fine of $3,000 or both. If law enforcement determines that there is probable cause that you have violated this order, the officer must arrest you whether or not the alleged violation was committed in the officer's presence. The prosecutor must provide a copy of this order to TLS. The sheriff's office is authorized to escort you one time to TLS's residence to retrieve or exchange property between the hours of 9 and 4, Monday through Friday. You must notify the court of any change of address, employment, phone number, or email. You must not leave the state of North Dakota without the advance express permission of the court. You must maintain at least weekly contact with defense counsel. You must notify the court. You must not use or possess alcohol or controlled substances unless prescribed. You must not possess a firearm or dangerous weapon. You must sign a promise to appear in waiver of extradition before release. You must complete a public defender application before release. You must personally appear for all scheduled court hearings. Your next court date is March 26, 2026, 1 p.m. at the Barnes County Courthouse in Valley City, North Dakota. You must submit a DNA sample and fingerprints before release. Ms. Shank, do you understand the terms and conditions of bail as I've said it?
Yeah, except for the fact that he comes to get his clothes. This isn't something that just started. This is from 2024. He's already been everything's been taken care of already.
Yeah, so that's fine. So, ma'am, I don't want you to talk about the facts of your alleged offenses. All I'm saying is, do you understand bail?
Yes, I do. I'll be here. I'll be in jail, so I won't miss any. I won't make bail. I'm not making bail. I have no chance of making bail. I'm not even going to try to make bail because there's no way to make bail. So I will be here. And
if you remain in custody for longer than 48 hours, you can request a bail review to determine whether bail remains appropriate or not. Bail reviews don't mean an automatic bail reduction. It means that a judge will review your bail and determine whether it remains to be appropriate. Bail can go up and go down. It can stay the same. But that's the bail as I've said it now. Do you understand that?
Yes, I do, Your Honor.
All right. We are adjourned in your matter.
The judge gave Alex one final warning before sentencing, while his mother faced 7 separate charges and strict bail conditions. Family loyalty turned into serious consequences in this emotional courtroom moment. Like, comment, and subscribe for more real court stories. Thanks for watching.